Hello and welcome to the Patent Agent Preparation Series. I am Priggya Arora, an engineer turned intellectual property lawyer. In the previous video, we discussed what is the requirement for patent filing. We studied the forms and the sections associated with it. So today we'll continue that discussion and we'll look into the provisions which are important for patent specifications. So in the last class, we discussed section 6, section 7 and section 8. In this class, we'll study section 9, section 10 and section 11, which relates to provisional and complete specifications, the contents of the specifications, and priority dates of claims of a complete specification. So I thought it would be better to directly go on to the act and go through these sections. Why? Because these sections in themselves have lot of scope of objective questions. So it would be better to learn these sections in detail. So let's go to the act itself. So according to section 9 of the Patents Act, section 9 discloses provisional and complete specifications. So provision 1 says where an application for a patent, not being a convention application or an application filed under the PCT designating India, is accompanied by a provisional specification, a complete specification shall be filed within 12 months from date of filing of the application. And if complete specification is not filed, the application shall be deemed to be abandoned. So what does that mean? This simply means like if you are filing a provisional application, there has to be a complete specification within 12 months. And if you fail to do so, your application will be considered as abandoned. So you have to be careful with the terms abandoned, withdrawn, rejected, and things like that, because every term has a different meaning. So in this case, the application will be termed as abandoned. Now let's go to subsection 2, which says where two or more applications in the name of same applicant are accompanied by provisional specifications in respect of inventions which are cognate of or of which one is modification of another, and the controller is of the opinion that whole of such inventions are such as to constitute a single invention and may properly be included in one patent, he may allow one complete specification to be filed in respect of all such provisional specifications, provided that the period of time specified under subsection 1 shall be reckoned from date of filing of the earliest provisional application. So what does this mean? This means that if you're filing more than one provisional applications, or you're filing one provisional applications, say for example, after 2 months you file another application, which is also a provisional applications, and because you are the applicant of the both inventions, that means a single applicant has filed multiple invention and that invention relate to single inventive concept. It does not mean that we first provisional relate to different invention, second provisional relate to different invention. They all are relating to single inventive concept. So in that case, on these two applications, I can file one single complete specification, but that complete specification needs to be filed within 12 months from the earliest provisional application. So earliest date of priority that we are claiming. So if we are filing one application, for example, on 1st April 2023, second application we are filing on 1st May 2023. We can file a complete application till 1st April 2024 because the earliest of the two application is of 1st April 2023. So we have to file within 12 months of earliest priority date, and of the provisional specifications. So let's come to provision 3, which is where an application for a patent not being a convention application or an application filed under PCT designating India is accompanied by a specification purporting to be a complete specification. The controller may, if the applicant be requests at any time within 12 months from date of filing of the application, direct that such specification shall be treated for the purpose of this act as provisional specification and proceed with the application accordingly. So this subsection only means, like, if I have filed a complete specification on 1st April 2023, now I want to convert that complete specification into a provisional specification. I can do that. How? I can file another complete specification at a later date and within 12 months of filing my first complete specification. And at that time, I can say consider my earlier filed complete specification as the provisional specification. So within a period of 1 year, you can convert your complete specification into provisional specification if you want to modify some of the aspects of your specification. Subsection 4, where a complete specification has been filed in pursuance of an application for a patent accompanied by a provisional specification or by specification treated by virtue of a direction under subsection 3 as provisional specification, the controller may, if the applicant so requests, at any time before grant of patent, cancel the provisional specification and post date the application to date of filing of complete specification. See, one of the important aspects of filing a provisional specification is to claim priority date. So now if I am filing a provisional specification, I am claiming priority date and then I am filing a complete specification. Now, any time before grant of patent, I can say to the controller that I do not want to claim priority from my provisional application. So if I do not want to claim priority of my from the provisional specification, what will examiner do? Examiner will give me a priority of complete specification, the date on which I filed complete specification. And this is called post dating to date of filing of complete specification. Like I have post dated my application to a date of filing of the complete specification. So that's why I am letting go of claiming of priority from the provisional application and I'm doing it at the date of filing of complete specification. So this is called post dating application to date of filing of complete specification. So this is about provisional and complete specifications. Now we'll move to contents of specification. This again is a very, very important section for the purpose of understanding what goes into specification, what does a specification require. And I would suggest read this with form 2, which is regarding provisional or complete specification. And you should also read this section with rule 13 and 15 because 15 relates to drawings. So that is also an important rule. And 16 is just about model. So that you can read this is just one line. So, but read it with rule 13 and rule 15 because there is a scope of lot of objective questions from section 10, rule 13 and rule 15. So let's have a look at this section. And this also will go by section, subsection by subsection because all of it is important for the purpose of objective examination. So first is every specification, whether a provisional or a complete, shall describe the invention and shall begin with a title sufficiently indicating subject matter to which the invention relates. So this means sometimes the question may come, what does title signify? What is the signification of a title? Then you should say that a title sufficiently indicates the subject matter to which our invention relates. So this is one of the important things, and title has to be there in provisional or complete application. So it has to go in both the application. Because we have this subsection, it is the practice which I follow for specifically, and I suggest for patent agent examination as well, like when you write your second paper, in the claims also we have three sections. Claims, like one claim will have a preamble, a transition phase, and a body. So whatever you write in the preamble, the same thing you can write as your title, because preamble should also indicate to the subject matter of the invention, and title should also relate to subject matter of invention. So at that point you will not have to think much, you can write preamble and the title together. So that is one tip for the second paper. But yeah, when we discuss drafting, I'll give you some more tips regarding how to draft the patent specification in your exam. So let's come to subsection 2. Subject to any rules that may be made in this behalf under the Act, the drawings may and shall, if controller so requires, be supplied for the purposes of any specification, whether complete or provisional, and any drawing so supplied shall, unless the controller otherwise directs, deemed to form part of a specification, and references in this Act to specification shall be construed accordingly. So this just means that your drawings, whatever drawings you submit, will be considered part of your specification. Similarly, we have subsection 3, which says model or sample. So if controller is requiring model or sample shall not be deemed to form part of the specification. So drawings would be considered part of the specification, and model or sample will not be considered part of the specification. And for models, we have Rule 16, which says models or samples shall be furnished under Section 10 only when required by the controller. So we do not have any obligation to submit models or samples, but drawings fall part of the specification. And whenever you submit drawings with your patent application, they are considered as formed part of the specification. Now, I'm not going through this rule in detail, which is Rule 15, but you should read this Rule 15. Why? Because it has specifications. For example, we need to submit the drawings on A4 sheets. What margins should be kept on top, top, left, bottom, and right side of the sheet? What are the requirements, like where do the applicant name comes, where do sheet number comes, where the signature of applicant or his agent comes. So I think these also can form part of objective examination. So for that purpose, you should be clear with Rule 15 as well. And as I told you, Rule 13 is again very important for this, for the purpose of objectives. So next, let's come to subsection 4. Again, it is a very, very important subsection. So 4A says every complete specification. So we have the word complete specification here. Shall fully and particularly describe the invention and its operation or use and the method by which it has to be performed. So let's try to break it down into elements and understand. So first term is fully and particularly describe the invention. This we call as written description requirement. So question may come, where is the written description requirement in our act? So answer is 4A. Now it has operation or use and method by which it has to be performed. So what does this indicate? It indicates that you are enabling a person to perform your invention. When you are enabling a person to perform your invention, it is called enablement requirement. So that is also in 4A. Next we have disclose best method of performing the invention which is known to the applicant and for which he is entitled to claim protection. So next question can come, where is best method requirement? So that the applicant needs to disclose best method of performing the invention. So that is in 4B. Next we have end with the claim or claims defining scope of the invention for which protection is claimed. So again, a specification should end with the claims or claims defining scope of the invention. So what does claim disclose? Claim disclose scope of the invention. So all these terms are important for our understanding and for the purpose of objectives as well. Then we have 4D, that a complete specification should be accompanied by an abstract to provide technical information on the invention. So again, it relates to abstract, and then I would, as I told you, I suggest that this needs to be read with section 13, where we have subclause 7, which is about abstract, like what should abstract include. So abstract should be specified under clause G of subsection 4 of clause 10, and it has things like it should be accompanied with title of the invention, it should provide concise summary of the matter which is disclosed in the specification. So all these three things are important. One of the important clauses, this abstract should not contain more than 150 words. So length of abstract is also important. So that's why section 13, rule 13, which indicates to specification, becomes very important. So next we have provided that the controller may amend the abstract for providing better information to third parties. So here it is written better information to third parties. Why? Because when we study publication, we know that along with publication, abstract is published. So the purpose of publishing abstract is third parties can come and read through the abstract and then figure out whether they want to read the full application or the specification or not, whether that specification is relevant to them or not. So in order to provide better information to third parties, the controller may amend the abstract, and maybe in the examination also, the controller may ask the inventor to or the applicant to amend the abstract. Next we have, this is also very interesting requirement, which is of a biological material. So in this subsection, we speak about this requirement and the Budapest Treaty, and let's go through the provisions. So if applicant mentions a biological material in the specification, so if in your patent invention you are using a biological material which may not be described in such a way as to satisfy the written description requirement or the best method requirement, 4A and 4B. Clauses A and B, and if such material is not available to public, and that material is not available to public and full information about that material is not known, the application shall be accompanied by depositing the material to an international depository under the Budapest Treaty. So if we are using such kind of material, we need to deposit the material in the international depository, which is authorized under Budapest Treaty. And we need to satisfy following conditions. What are the conditions? The conditions are the deposit of the material shall be made not later than date of filing of the application in India, and reference thereof shall be made in the specification within the prescribed period. That means whenever you have such kind of material and you are using that material in your patent, in your invention, then you need to submit that material in the depository before date of filing of the patent application in India. And reference of it, that means when you submit that application in the depository will give you some reference number. So that reference should be made within the prescribed period. Now, what is this prescribed period? If you come to rule 13, you will know that this prescribed period is of 3 months from date of filing of the application. So the period within which reference to the deposit shall be made in the specification under subclause A of clause 2 of subsection 4 of section 10 shall be 3 months from date of filing of the application. So whenever we have this, like there is a depository, we need to give that reference within 3 months from date of filing of the application. Provided that in case of request for publication under Rule 24A, such reference shall be made on or before the date of filing such request. So if you are asking the government or the patent office to publish your application, so you should file that request only when you have already put reference in your patent specification. So if there is no reference, then don't make the request of publication. So ideal period is 3 months from date of filing of the application. Okay. Now we have clause B, where all the what we need to include in the specification, or all the available characteristics of the material required for it to be correctly identified or indicated are included in the specification, including name, address of the depository institute, date and number of deposit of the material at the institute. So we need to give these details in the specification. Then we have access to material is available in the depository institution only after date of application of patent in India, or if a priority is claimed after the date of priority. So you need to, whenever you submit the material in the depository institution, then other people can come and access that material so that they gain information what material is used. So for that purpose, when that material would be available for other people, it would be available only after date of application of patent in India or date of priority. Then it should disclose source and geographical origin of the biological material in the specification when used in an invention. So we need to disclose source and geographical origin of biological material. So to give you an example, for example, if an algae of a particular location, an algae of river X, or an algae growing in a particular region X is used for water treatment, is used in an invention for water treatment. So and if the specifications of that algae are not known to the public or not available to the public, then we should submit that algae in the in the depository institution, and we should give references, and we should fulfill requirements ABCD as we have just discussed. Next we have subclause 4A, which says in case of an international application designating India, title, description, drawings, abstract, claims filed with the application shall be taken as complete specification for the purpose of this act. So in your international application, whatever is mentioned will be taken as complete specification in India. Next we have clause 5, which is again important because a question may come, where is unity of invention described in our act? So one was it was defined in section 7. Next we have 10.5, which is claim or claims of complete specification shall relate to single invention or to a group of invention linked to form a single inventive concept. That this we also studied when we discussed section 7 in the last class. So we have to fulfill this requirement. That's why if we are not relating to our invention to a single inventive concept, we have the provision of divisional application under section 16. So the claim or claims of the complete specification shall relate to single invention or to a group of invention linked to form a single inventive concept, shall be clear and succinct, and shall be fairly based on matter disclosed in the specification. So they should relate to single inventive concept, shall be clear and shall be consistent, and should relate to the subject matter of the specification. Then we have declaration as to inventorship. This also we studied in the last lecture along with form. So declaration as to inventorship needs to be given in form 5, and the associated rule is rule 13.6. Whenever we are filing a patent specification, we need to put who is the true and first inventor of the specification. This is the requirement. How do we put that? We put that in form 5, and the associated rule is rule 6. So let's read that rule as well. Like whenever we have a complete specification, a declaration as to inventorship of the invention shall be filed in form 5 with the complete specification, or at any time before expiry of 1 month from date of filing of the complete specification, as the controller may allow on application made in form 4. So this is an important aspect. Why? Because ideally we should submit declaration as to inventorship with the complete specification or whenever we file the application. So in practice, we do generally file it with the provisional specification also, but if you have not done, you can do it with the complete specification. And if you fail to do so, then you'll have to request the controller for an extension, and that request for extension is filed in form 4. So form 4 is specifically for extension of timelines, and it has certain criteria to be filed, which we'll discuss in one of the sections, and where specifically if we have to get the leverage of 1 month from date of filing of the specification while filing form 5, we need to submit form 4 as well. Then let's come to 10.7. Subject to foregoing provisions of this section, a complete specification shall be filed after provisional specification may include claims in respect of developments of addition to the invention which was described in the provisional specification, being developments or additions in respect to which applicant would be entitled under the provision of section 6 to make a separate application for patent. So according to this section, if you are filing a complete specification after a provisional specification, so that complete specification can include certain developments or additions that you are making to your inventions. But for example, you're filing, this is not related to this subsection, but if you're filing a patent of addition, then the application date of your main application would be counted from date of provisional specification only, because we are claiming priority from that date. Okay, so here it is important to understand, like if you're making developments and additions in the complete specification, that is okay, because we are relating it to the single invention. So we can do that while we are filing a complete specification. So that was all about contents of the specification. And as I told you, you should go through section 10 and rule 13, 15, and 16 for the purpose of specification. I am skipping rule 14. Why? Because this specifically relates to amendment of specification that we'll study in one of the lectures when we study sections related to amendments. So next we have section 11. All mostly situation-based questions in objective paper comes from this this section, and that's why this section is very important. It's a bit tricky also, but if you get through the concept once and you understand the concept once, then you'll not make any mistake. But from this section specifically, you can anticipate a question related to situation based question, where you'll be asked things like what would be the priority date of claim in a situation where this happens. Okay, now let's go through this section also once. So section 11 is about priority dates of claims of a specification, where it says in subclause 1, it says there shall be a priority date for each claim of a complete specification. So mostly people get confused with the priority date, and they'll expect that if we have one specification, the priority date is one. But that is not the case. Ideally, in general cases, we consider that priority date is the earliest of filing what we have done related to the same invention. That is the priority date. But in cases of infringement, when we have to analyze the invention, generally priority date of each claim is considered, and this subsections also clearly state that there shall be a priority date for each claim of a complete specification. Now a point to remember here is, or logic to remember here is, the day you have disclosed something for the first time will be the priority date. So the day on which you have disclosed something for the first time in your patent application will be your priority date. I think I'll repeat it again because I want this to land. The date on which you have disclosed something for the first time in your patent application would be the priority date. So remember this statement, and then we'll go through the other subsection so that it becomes clear that what situation can come up. So where a complete specification is filed in pursuance of single application accompanied by provisional specification or a specification which is treated as provisional specification under subsection 3 of section 9, and the claim is fairly based on the matter disclosed in the specification referred to in clause A or B, which is the provisional specification, the priority date of that claim shall be the date of filing of the relevant specification. So if you have disclosed the subject matter in the provisional specification and then you are filing a complete specification on the same subject matter, you have not included new elements in the complete specification, you are filing complete specification on the matter which was disclosed in your provisional specification, then because that element was disclosed in the provisional specification for the first time, the priority date of that claim would be also the date of filing of the provisional specification. It would not shift, it would be the date of filing of the provisional specification. Let's come to clause 3, where the complete specification is filed or processed with in pursuance of 2 or more application accompanied by such specification as mentioned in subsection 2, and the claim is fairly based on matter disclosed in one of those specifications, the priority date of that claim shall be the date of filing of the application accompanied by the specification. So let's study clause B as well, and then I'll explain. Partly in one and partly in another, the priority date of that claim shall be date of filing of the application accompanied by the specification of the later date. So as I told you, the day on which you are disclosing your matter for the first time, that date would be considered as priority date. So for example, you have disclosed element, suppose there are 2 provisional applications. One is filed on 1st April 2023, other is filed on 1st May 2023. And now you have filed the complete specification with the claim, and the subject matter of that claim was disclosed on 1st May 2023. Then priority date of that claim would be considered as 1st May 2023. If subject matter of that claim was disclosed on the application which was filed on 1st April 2023, then priority date of that claim would be considered as 1st April 2023. So whenever the subject matter was disclosed for the first time, that date would be considered as priority date. Now there may be a situation where you have drafted the claim which was partly disclosed in the application which was filed on 1st April 2023, and partly it is disclosed in the matter which was filed on 1st May 2023. So now partly it is disclosed in one application, partly it is disclosed in second application. So I can only consider that first time the full subject matter was disclosed in the second application, because first application subject matter would be incomplete. So I'll consider that for the first time the subject matter was disclosed in the second application, which was filed on 1st May 2023. So in this case, the date of priority of the claim would be considered as 1st May 2023, because it was partly disclosed in the first application. It was not fully disclosed in the first application. So next, let's come to clause 3A, where a complete specification based on a previously filed application in India has been filed within 12 months from date of application, and the claim is fairly based on subject matter disclosed in the previously filed application. The priority date of that claim shall be the date of previously filed application in which the matter was first disclosed. So like I told you, if it is disclosed in the priority in the provisional specification or an application which was filed before that, we can claim priority date on from the day of filing of that application, because the subject matter was disclosed for the first time in that application. Then we have clause 4, where the complete specification has been filed in pursuance of a further application made by virtue of subsection 1 of section 16. What is subsection 1 of subsection 16? It is the divisional application. If I filed an application and I am now dividing it into two applications, and the claim is fairly based on the matter disclosed in any earlier specification, provisional or complete, as the case may be, the priority date of that claim shall be the date of filing of that specification in which the matter was first disclosed. So if I am dividing my application into two, and the earliest file application had the priority date, and the subject matter was also disclosed in that application from which I'm claiming the priority date, then that would be considered as date of priority of my claim. Because why? Because simply the subject matter was disclosed in that application, where whenever the subject matter is first disclosed, that date is considered as priority date. Where under the foregoing provisions of this section, any claim of a complete specification would, but for the provision of this subsection, have two or more priority dates, the date of that claim shall be earlier or earliest of those dates. Why we have this provision is, for example, I have filed an application in the US. I filed one application in the US on 1st April 2023, and another application I've filed in the US on 1st May 2023. So I filed two applications in the US, and in Indian application, I am claiming priority date from both of these applications. Then what would be the date of priority of my claims? The date of earliest of those dates. So it would be 1st April 2023. In any case to which subsection 2, 3, 4, 5 do not apply, like provisional specification is not there in any of that case, and if we are not claiming any priority date from the international application under 137, so if that is the case, provisional application is not there, international application is not there, I'm not claiming any priority while filing my application, date of filing of the complete specification would be considered as priority date. The reference to date of filing of the application of the complete specification in this section shall, in cases where the application has been a post dating under section 9 or section 17, or as the case may be, an antedating under section 16, be a reference to the date as to post-dated or antedated. So let us try to understand what is post-dating and antedating. Post-dating is when I'm moving my priority date forward. For example, just we in this lecture only, we studied the concept where we converted a complete specific, where we said that I do not want to claim priority from my provisional specification and I want to claim priority from my complete specification. So in that case, we studied that there would be a post dating. So section 9(4). So in this section, there would be post dating. Why? Because I am telling the examiner that I don't want to claim priority from the provisional application and I want to claim priority from the complete specification. So the priority date is moving to the complete specification. So an example of post dating is this. We have post dating in another section also, which will come through in further lectures. So whenever there is a case of post dating or there is a case of anti-dating. What is anti-dating? Anti-dating under section 16. So I think in one of the interview or in one of the objective questions of the Patent Act, the term there was a question on anti-dating. So anti-dating simply means when you are dividing the application, you are claiming priority date from an earlier date. So that is called anti-dating. Like when you're dividing the application, the second application will have the same date as of the main application. Why? Because you are dividing the date. So in that case, it would be called as anti-dating. So whenever we have these, the reference to date should be given in the specification or in the filing. Next, we have a claim in the complete specification of a patent shall not be invalid by reason only of the publication or use of the invention so far as claimed in that claim on or after date of priority of such claim. So if my patent application will not be rejected if there is a publication after my date of priority. So it would not be rejected on this reason. So a claim cannot be rejected if after date of priority, such subject matter is disclosed to public. So that is about publication. And in clause B, we have again a claim in the complete specification of the patent shall not be invalid by reason only of the grant of another patent which claims the invention so far as claimed in the first mentioned claim in a claim of same or later priority date. So if my patent application will not be considered as invalid or my claim will not be considered as invalid if there is a second patent which is granted or another claim which is granted after my date of priority. So that's why priority date is very, very important. Anything done after my date of priority, and if it is similar to my invention, then my invention will not be considered invalid on this reason. But at the same time, if before the date of priority, the subject matter is disclosed or it is known to public or it is used in public, then my invention can be considered as invalid. So I think this was about section 9, 10, and 11. And as I told you, there is a lot of scope of objective questions. So study these sections well, study rules and forms along with it, and you will be good to go. In the next class, we'll probably study publication of the patents. And yeah, so that's all for today. Thank you.